Can I congratulate everybody on their very prompt arrival? Our next debate will be on Clause 39 stand part. We now come to the question that Clause 39 stand part of the bill. I ask the Minister to rise.
Thank you very much, Dame Siobhan. It's a great pleasure to see you as the fourth member of our committee and welcome you to the Chair. It's a pleasure to serve with you directing us. This clause is a simple consequentials clause which removes reference to an amendment made by the Illegal Migration Act 2023 and the Safety of Rwanda Asylum and Immigration Act 2024, where they no longer serve a purpose. Upon passage of these two pieces of legislation, it was necessary to amend existing Acts of Parliament to cross-reference them and to enable the enactment of provisions within them. As we know, very few, if any, of these provisions were ever properly commenced or enacted. And since this government intends to repeal the Safety of Rwanda Act and large parts of the Illegal Migration Act, which we spent most of this morning discussing, Dame Siobhan, these references no longer serve any practical purpose and should therefore be removed from the four existing Acts of Parliament.
Thank you, Dame Siobhan. It's a pleasure to serve with you and the Chair this afternoon, as it was yesterday afternoon. It's good to see you 2 days in a row. This clause, as the Minister says, makes consequential amendments necessary as a result of the clauses the Minister rightly says we discussed this morning, namely Clause 37, repealing the Safety of Rwanda Act 2024, and Clause 38, repealing sections of the Illegal Migration Act 2023. As we do not support either of those repeals, we do not support this repeal either, and we do not support this clause standing part of the bill.
Are there any other members of the committee who wish to call the Minister?
I think we've had out our debates about the content of these bills. These are truly miscellaneous aspects, although I understand the logic of the argument that the Honourable Lady, the Member for the Wirral of Kent, has just made. I certainly hope that we will press on and pass Clause 39 as part of the bill.
The question is that Clause 39 stand part of the bill. As many are of that opinion, say aye.
Aye.
And to the contrary, no.
No.
Aye. No. Aye.
Division.
How exciting.
How's it going to go? Lock the doors.
Sarah Hall?
No.
Jane Potterill?
Aye.
Dame Angela Eagle?
Aye.
Will Forster?
Aye.
Tom Hayes?
Aye.
Katie Lamb?
No.
Martin McCluskey?
Aye.
Margaret Mullane?
Aye.
Kenneth Stevenson?
Aye.
Mike Tapp?
Aye.
Matt Vickers?
No.
Joe White?
Aye.
And Pete Wishart?
Abstain.
The ayes were 9, the noes were 3, so the ayes have it, unlock. We now come to the question that Clause 40 stand part of the bill, with which it will be convenient to debate Schedule 1. I call the Minister.
Thank you very much, Dame Siobhan. Clause 40 introduces Schedule 1, which will allow the governance arrangements for the Immigration Services Commissioner and Deputy Commissioner to be made more flexible. This will bring it in line with other public appointments by allowing for interim or shorter appointment lengths. Schedule 1 sets out that the Commissioner and Deputy Commissioner are to hold office for a term not exceeding 5 years. This allows for appointments to be less than 5 years, whereas currently it is a fixed 5-year term. Schedule 1 will make it discretionary to appoint a Deputy Commissioner, allowing for the governance arrangements to remain flexible to meet the demands of the organisation. Schedule 1 will enable the Home Secretary to appoint a senior experienced member of staff to act in the Commissioner's place in certain circumstances. It's to be used, for example, to ensure cover is in place during a public appointment process, where there is a vacancy in the Commissioner and Deputy Commissioner posts. So it does not replace the provision to appoint a Deputy Commissioner and will ensure continued regulatory oversight of immigration advisors, which is the point of this organisation. This schedule will mean that the work of the Immigration Services Commissioner will continue and will operate more flexibly to ensure good immigration advice is readily available, which is critical to the effective running of a coherent, efficient and fair immigration system.
Thank you, Chair.
Katie Love.
As the Minister, of course, has outlined, Clause 40 inserts Schedule 1 into the Bill, which provides the Immigration Services Commissioner is not to hold office for a term exceeding 5 years. The current regime is based on there being a Commissioner and Deputy, so Schedule 1 sets out that the Commissioner may appoint a Deputy. There is also a provision to enable a member of the Commissioner's staff to act in the Commissioner's place in certain circumstances, exactly as the Minister says, such as both the roles of Commissioner and Deputy being vacant. This effectively allows for the appointment of an interim Commissioner. As we said in evidence to the committee, these amendments do not seem to us to have operational consequence. We will not oppose them.
Does the Minister want to, or any other members want to, Minister want to say anything? The question is that Clause 40 stand part of the bill. As many of that opinion say aye.
Aye.
On the contrary, no. I think the ayes have it, the ayes have it. Schedule 1 has been debated with Clause 40. We will therefore proceed straight to the vote. That Schedule 1 be the first schedule of the bill. As many are of that opinion say aye.
Aye.
To the contrary, no. I think the ayes have it, the ayes have it. We now come to Amendment 7 to Clause 41, with which it will be convenient to debate Clause 41 stand part. I call Pete Wishart to move Amendment 7.
Thank you ever so much, Mr. McDonald. It's great to see you in the chair. It makes a pleasant change from what we've had in the course of the past couple of years. And I say that in the nicest way to Mr. Stewart. Clause 41 of the bill introduces a significant expansion of detention powers, allowing individuals to be detained from the moment a deportation is considered rather than waiting for a formal deportation order. But the main concern that I have with this particular clause is to apply retrospectively, meaning it would legally validate past detentions that were previously unlawful. This provision, as you would expect, Ms McDonagh, has sparked serious concerns among legal experts, human rights organisations and advocacy groups, raising critical questions about the rule of law, human rights and judicial oversight. Now, we had the Immigration Law Practices Association with us as part of the McLaren evidence session, and they have expressed great concern with this provision, saying, "We are concerned with the dangerous precedent which would be set if unlawful deprivation of liberty were to be treated as lawful. Such retrospectivity undermines the rule of law and remains wholly unjustified in the materials accompanying the bill." Now, I've looked at this and there doesn't seem to be any sufficient justification for this exceptional measure, and it warns us that it could effectively rewrite history, denying justice to individuals who could have sought remedies for unlawful detention. Now, Amnesty International, who have again given us very good evidence to this committee, has also voiced strong objections highlighting how detention powers have expanded significantly while judicial oversight has weakened, leading to risks of serious injustice. Bail for immigration detainees has stressed that Clause 41 further criminalises migrants and refugees, urging instead for a system that upholds human rights and dignity. And this clause, combined with the Illegal Migration Act, could lead to longer, more expensive and potentially unlawful detentions in breach of Article 5 of the European Convention on Human Rights. Now, The government's own impact assessment acknowledges that Clause 41 effectively makes lawful past detentions that were not compliant with due process at the time. Yet the ECHR memorandum does not properly address whether this retrospective validation aligns with the fundamental legal safeguards of Article 5, and I would particularly like the Minister to address these concerns. Clause 41 therefore undermines accountability, weakens judicial scrutiny and risks setting a dangerous precedent where the government can retroactively legitimise actions that would otherwise have been unlawful. Given the weight of these concerns, there is a strong case for leaving out the retrospective provisions from Clause 41, and that's what my Amendment 7 seeks to do in the order paper today. Upholding the rule of law means ensuring that detention powers are subject to proper legal safeguards and that individuals are not denied their fundamental rights through legislative backtracking. I beg to read Mr MacDonald. Thank you.
Amendment 7 proposed to Clause 41 as on the amendment paper. The question is that the amendment be made. I call the Minister.
Thank you very much, Dame Siobhan. The purpose of Clause 41 is to clarify existing powers of detention pending deportation in paragraph 2 of Schedule 3 of the Immigration Act 1971. The clause ensures that the Secretary of State can detain individuals once they've been notified that deportation is being considered. It also aligns the power to detain with the power to take biometrics and to search for nationality documents. This is because the taking of biometric information and any other searches will ordinarily take place at the point that somebody is detained. The effect of Clause 41 is to make clear that a person subject to deportation may be detained at any stage of the deportation process. It's a strengthening of existing power. It's not creating a new power. So it clarifies the power that has always existed and been used for this purpose. The effect of the clause is also to confirm that the Secretary of State may take biometrics and search for those documents. Since Clause 41 is clarifying existing powers, the detention provisions it contains are regarded as always having had effect. So I think that it's extremely important for members to understand what this clarification of the powers of detention means. If a person's subject to deportation on the basis that the deportation is conducive to the public good, they may be detained at any stage of the deportation process. It's extremely important that the Home Office can detain those it's seeking to deport on this basis. Some of these foreign national offenders pose a high risk of harm to the public. Therefore, the inability to detain them could have a direct impact on public safety. The clause makes it clear that it's lawful to detain a person once they are notified that the Home Office is considering whether to make a deportation order against them. This is not a new detention power, and I think it's been misunderstood in some of the commentary outside of this place. It's clarifying an existing power to ensure that there is no ambiguity about when someone subject to a conducive deportation can be detained. The accurate identification of such people is a very important issue. The clause also makes consequential amendments to existing powers to search detained persons' potential deportees for documents which prove their identity or nationality and take their biometrics upon being detained. Clause 41 sets out the power to detain pending deportation as the Home Office has always understood it to operate. It's therefore right that this provision applies respectively, and this deals with the Honourable Member's Amendment number 7, which seeks to remove the retrospective element of the clause. Clause 41, as set out, is clarifying the existing statutory powers of detention. It's important for public safety reasons why these powers need to be put beyond doubt, which is what this clause in this bill does. It clarifies the powers as the Home Office has always understood them to operate, and there'll be no operational impact that we can assess or increased use of this power, and no effect on people in relation to whom this power has been exercised. It's entirely right that these provisions apply retrospectively in these circumstances. So I ask the Honourable gentleman wants to... Yep.
Pete Wishart.
Just about the justification for these powers and why she feels them necessary. I'm not hearing any compelling reason about why they have to be introduced retrospectively. What on earth is that supposed to help her with? And she knows the range of concerns that's been raised by a number of legal organisations, and I wish she would address their concerns about the consequences of this clause.
What we're seeking to do, and what this clause does, is to put beyond any doubt that the Home Office has the power to detain in conducive deportation cases at the earliest point. It has been doing this for many years. The clarification in this clause applies retrospectively to ensure that those who have been detained in the past have not been detained unlawfully. We don't believe they have, but this puts it beyond doubt. So just to clarify, this is not an extension of deportation powers. It's putting beyond doubt in this bill that the understanding of how and when these powers can be used at the earliest opportunity, in this case, if it's a conducive deportation, the power to do that has always existed, and the power to detain at the earliest opportunity has also always existed. The Honourable Gentleman's amendment is supported, then that would cast doubt on many of the deportations, the arrests and the detentions ahead of deportations that have happened in the past. And I don't think that that would be what the Honourable Gentleman would really want to do. So just to reassure one final time, this is not an extension of deportation powers, it's a clarification of the way they've always understood to be worked, just to put beyond legal doubt that if somebody is being detained pending deportation, they can be detained at the earliest opportunity, and they can be lawfully detained at the earliest opportunity. That understanding is what has always been the case, but this clause puts that understanding beyond any legal doubt.
Thank you, Chair. Clause 41 confirms that the Home Office may detain someone subject to deportation from the point at which the Home Office serves the notification that deportation is being considered, where that deportation is conducive to the public good. We support this provision to allow for detention before a deportation order is signed. However, this only applies if the Secretary of State has notified that person in writing. So can I seek reassurance, please, from the Minister that the requirement for a written notice will not build any delay into this process? We also support the provision in Clause 42 to allow the Home Office to capture biometrics at the new earlier point of detention.
Pete Wishart?
Yes, thank you once again, Mr. Green. I won't detain you much other than just to say I'm not trying to do anything. I don't like Clause 41. I think the extension of the deportation powers I think is overwhelming, and I don't really believe that they're actually required. But I do not like this retrospection one bit, and I've not secured an adequate explanation from the Minister about why these are necessary. So, Ms McDonough, I would like to test this in committee and put it to the vote.
Thank you for clarifying. That was going to be my next question, unless there is anybody else who wishes to contribute.
Might I just get a response from the Minister?
I'm happy to give the Honourable Lady the assurance that she sought. If somebody is going to be detained, it will always be done with written notice, and that shouldn't delay anything. It hasn't in the past.
Okay. The Honourable Member wishes to move this to a vote. Therefore, Amendment 7 proposed to Clause 41 as on the amendment paper. The question is that the amendment be made. As many of that opinion say aye.
Aye.
To the contrary,
No.
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 No. Yeah.
Did we proceed to?
Oh, yeah. Division. This can be on your newsletter, Pete. Lock the doors.
Sarah Ball.
No.
Jade Butterill.
No.
Dame Angela Eagle.
No.
Will Forster.
Aye.
Tom Hayes.
No.
Katie Lamb.
No.
Martin McCluskey.
No.
Margaret Mullane.
No.
Kenneth Stevenson.
No.
Mike Tapp. Matt Vickers.
No.
Joe White.
No.
Pete Wishart.
Yes, so the nose.
The ayes were 2, the noes were 11, so the noes have it, unlock. We now come to clause 41 stand part, which has been debated. The question is that clause 41 stand part of the bill. As many are of that opinion, say aye.
Aye.
To the contrary, no. I think the ayes have it, the ayes have it. We now come to question that clause 42 stand part of the bill. Minister.
Thank you very much, Dame Siobhan. You're getting a lot of practice, I think, with the locking and unlocking and having divisions. It's quite exciting this afternoon. Clause 42 modernises our powers to capture biometric information so that we have greater flexibility about who can take them. This will enable a wider range of appropriately trained people to take biometric information, strengthening resilience in processing following instances of small boat crossings or unexpected arrivals. In a situation where it's essential to capture biometrics at the earliest opportunity and through streamlined processes, we will be able to utilise our resources more effectively. For example, it will enable contractors working at a short-term holding facility, for example, to capture biometrics in the same way as other contractors based in detention centres currently do. The clause includes a power to make secondary legislation where there is a need for others to be able to capture biometric information. This is a future-proofing of the legislation. These are sensible and necessary measures to ensure that we can identify people, enabling us to quickly identify them and establish whether they pose a threat to public safety if they've arrived in an irregular or illegal way.
Katie Lamb.
Thank you, Chair. As I have already noted, we are essentially supportive of Clause 42, which, among other things, allows a person employed by a contractor under a short-term holding facility to be an authorised person to take fingerprints. This clause also includes a regulation-making power to allow other types of people to be authorised for this purpose. Can I ask the Minister how the regulation-making power is intended to be used? Are there currently other categories of people that the Secretary of State or others in the Department would like to authorise to take fingerprints? Or, as I think the Minister, in fact, just said, is this essentially future-proofing?
Minister.
Thank you, Dame Siobhan. It's essentially future-proofing, and clearly if another category, a range of people came available, then we may, in order to future-proof this power, be able to use that regulation-making power to ensure that they were taking biometrics lawfully.
Do I see any other members who would like to add to the debate? Does the Minister wish to say anything further? The question is that Clause 42 stand part of the bill. As many are of that opinion, say aye.
Aye.
Of the contrary, no. I think the ayes have it, the ayes have it. We now come to the question that Clause 43 stand part of the bill, with which it will be convenient to debate Clause 44 stand part. Minister.
Thank you very much, Dame Siobhan. Clauses 43 and 44 cover the creation of 2 new offences concerning articles for use in serious crime. Law enforcement agencies are increasingly encountering individuals in possession of or supplying articles suspected to be intended for serious crime. However, proving intent or knowledge for a prosecution is often difficult, as the connection to a specific crime may not be immediately clear, and facilitators therefore frequently go undetected. Clause 43 introduces 2 new criminal offences to address this challenge. The first offence criminalises the possession of specified articles, while the second targets the importation, manufacture adaptation, supply or offer to supply of these articles, where there is a reasonable suspicion that they are going to be used in a serious offence. The specified articles include templates for 3D printed firearms, components, pill pressers and vehicle concealments. These concealments are particularly concerning in smuggling operations, as they are often used to hide individuals for irregular immigration purposes. The accused will need to prove that they did not intend for the article to be used in a serious offence, or could not have reasonably suspected it, given the few, if any, legitimate uses for articles, the articles that I've just mentioned. These offences will be trialable either way, with a maximum penalty of 5 years imprisonment, a fine, or both. Clause 43 defines serious offences broadly, including drug trafficking, firearms offences and assisting unlawful migration, as outlined under Schedule 1 to the Serious Crime Act 2007. This clause strengthens the ability of law enforcement agencies to target those facilitating serious crime by closing legal gaps and addressing emerging criminal tools. Clause 44 defines the specific articles to be included in the new criminal offences in Clause 43 of the Bill. These articles, as I've just said, are templates of 3D printed firearms or their components, pill pressers and encapsulators and vehicle concealments. Law enforcement agencies have been clear that these articles are being increasingly used by organised crime gangs and will continue to be used unless we take action now. 3D printed firearm templates are increasingly being used by organised criminals, though they're not illegal to possess at present. Pill pressers are being used to manufacture illicit drugs, particularly benzodiazepines. Similarly, vehicle concealments have become a significant concern for law enforcement agencies aiding in people smuggling and irregular migration. Clause 44 also provides the Secretary of State with the power to amend the list of specified articles, allowing the law to adapt to emerging threats. Any changes will be subject to the draft of the affirmative procedure. The Home Office will continue to work closely with law enforcement agencies and other partners to monitor and update this list, ensuring that it remains relevant as criminal tactics evolve. By capturing these articles, the aim is to disrupt the enablers and facilitators who profit from supplying goods to organised crime. I move.
Katie Lamb.
Thank you very much, Chair. These clauses seem to us to be broadly reasonable, although we do have a few questions where I would very much appreciate some clarification from the Minister. Clause 43 creates two new offences of possession of articles for use in serious immigration crime and importation, manufacture, supply or offering to supply articles for use in serious immigration crime. Can the Minister explain to the committee, please, whether she feels that the UK Border Force currently has the right capabilities to identify and intercept harmful materials that are captured by this clause? Clause 43 reverses the evidential burden of proof in that a person charged with offences under this clause can successfully prove their defence if they provide enough evidence to raise a question about the issue in court and the prosecution cannot prove the opposite beyond reasonable doubt. Could the Minister explain, please, why the decision has been taken to do this? The maximum penalty for the offences created under this clause is imprisonment for 5 years or a fine or both. Might the Minister please explain how and why these penalties were decided upon? And Clause 44 defines relevant article for the purposes of offences created in Clause 43. Could the Minister explain, please, whether Clauses 43 and 44 provide any operational benefit in terms of tackling smugglers operating abroad, and if so, how?
Anybody else wish to contribute to the debate? I call the Minister.
And thank you
Sorry, Minister. Tom Hayes.
Thank you, Chair. It's a pleasure to serve under your chairpersonship. I wanted to briefly dwell on this particular clause because it feels to me that it embodies quite a significant theme in this bill, which is really about preparing our country for the challenges that we face today, but also the challenges we're facing to a greater extent in the future. And I think talking particularly about the risk that's posed to our country's security from 3D printed firearms is so important in that context. So I just wanted to particularly commend the campaigning of the Honourable Member for Birmingham Edgbaston, who has done an enormous amount of work on this issue of 3D printed firearms. It's a serious threat to our security. They present a new challenge to law enforcement because they can be easily made at home and they're untraceable and undetectable. Indeed, there are files containing IKEA-like step-by-step guides to 3D print firearms at home that can be downloaded from the web in as little as 3 clicks. That is terrifying. And if we're able, through this bill, to be able to tackle that, that feels like a really significant contribution. I just want to close by saying that we know that law enforcement are calling out for these powers. In oral testimony, we heard comprehensively from operationally and frontline focused people, senior leaders, that they wanted to be able to do more to get ahead of these threats. And I think one of the great things about this bill is that it's listening to the experts, it's giving them the resources they need, and as a consequence, we'll be able to securitise our border, but also make sure that people are safe in our streets as a result.
Thank you very much, Dame Siobhan. The Honourable Lady opposite may, well, perhaps she won't, but draw some familiarity with these suggestions in clauses 43 and 44, because they were actually in a bill that her predecessor, now the Shadow Home Secretary, was putting before the House, which was interrupted by the general election. And oddly, I was chairing that bill committee in the last Parliament, listening to him make a speech about this. So I hope that there won't be any real reason for there to be an objection to the powers that we need to take in clause 43 and 44 to make it easier to disrupt and prevent the harm that comes from serious organised crime, and some of the tools that they use and the facilitators that enable them might not be at the scene of the crime, but they've enabled a lot of harm to happen by supplying or importing the goods that we've mentioned, that I've mentioned in clause 43 and 44. So they're two sets of offences. They're designed to target different types of activity and handle commonplace these articles, and the Honourable Lady asked about the evidential burden. These articles don't have ordinary, normal uses that I would think were legitimate. Printing 3D guns, having pill presses so that you can produce your own drugs for street sale. None of this seems to be as legitimate as, say, I don't know, purchasing a boat engine or indeed a boat. And so, given that there are no real legitimate uses for items like this, we think that placing the evidential burden on the defence to explain why on earth the person charged with possessing them has them is wholly reasonable. The reason for doing this is to disrupt serious organised crime efforts to penetrate our border with either drugs, the paraphernalia of producing them, guns, any of the things that go along with serious organised crime activity in this country, and thereby keep people safe. And I hope that, given that explanation, that members of the committee will feel that it's a good thing to support both the clauses that we're discussing in this particular part of the bill, clause 43 and clause 44.
The question is that clause 43 stand part of the bill. As many are of that opinion, say aye. Aye. To the contrary, no. I think the ayes have it. The ayes have it. Clause 44 has just been debated, so we go straight to the vote. The question is that clause 44 stand part of the bill. As many are of that opinion, say aye. Aye. To the contrary, no. I think the ayes have it. The ayes have it. We now come to the question that clause 45 stand part of the bill. Minister.
Thank you. Once more, Dame Siobhan. Clause 45 amends the Proceeds of Crime Act 2002 to include offences related to the possession and supply of articles intended for serious crime, as outlined in clause 43 of this bill. This amendment enables law enforcement agencies to seize the assets of individuals convicted under Clause 43. Specifically, it adds offences related to things for use in serious crime to the criminal lifestyle schedules for England and Wales, Scotland and Northern Ireland. A defendant convicted of an offence listed in these schedules will automatically be deemed to have led a criminal lifestyle and to have benefited from criminal conduct over a period of time. This means that assets obtained or spent in the 6 years prior to conviction are presumed to be derived from criminal conduct and are subject to confiscation unless the defendant can prove otherwise. However, the court is not required to make this assumption if it would result in injustice or is shown to be incorrect. Confiscation orders are calculated based on the defendant's monetary gains from crime, known as the benefit, and the assets that they have available to them when the order is made. Orders are made to reflect the amount gained from crime and can be increased if the defendant's finances improve. Non-payment of orders can lead to the defendant returning to prison. By including these offences in the Proceeds of Crime Act, criminals who profit from facilitating crime are targeted financially, disrupting both the crime and the financial gains that support it.
Katie Lamb.
Thank you, Chair. Clause 45 allows the relevant articles listed under Clause 44 to be confiscated under the Proceeds of Crime Act. We support this measure.
Nobody else wishes to come into the debate? The Minister? The question is that Clause 45 stand part of the bill. As many are of that opinion, say aye. Aye. The contrary, no. I think the ayes have it. The ayes have it. We now come to the question that Clause 46 stand part of the bill. Minister.
Thank you very much, Dame Siobhan. The purpose of Clause 46 is to remove any ambiguity about the court's power to impose electronic monitoring as a condition of a serious crime prevention order or interim serious crime prevention order. As currently drafted, the clause applies in England and Wales for any serious crime prevention orders or interim serious crime prevention orders, and in Scotland and Northern Ireland in terrorism-related cases only. However, since the bill's introduction, further legal complexities have come to light regarding the devolved government's powers to impose an electronic monitoring condition. Pending agreement from the Scottish Cabinet Secretary, an amendment will be tabled to remove this express provision for Scotland. Northern Ireland's position is still to be determined. So, Dame Siobhan, there's a devolution complication that I'm just pointing out to the committee at this point in time, and certainly keep the committee informed of how those discussions are develop as we go on. I think that electronic monitoring serves as a deterrent. It serves as a deterrent, but it also improves the detection of any breaches. If the subject violates the conditions, it enables quicker intervention by law enforcement agencies. The clause outlines specific requirements for both the courts and the individual, including the obligation for the subject to consent to the installation and maintenance of monitoring equipment and to avoid tampering with it. Additional safeguards are included. For example, electronic monitoring can only be imposed for up to 12 months at a time, with the possibility of extension. A further safeguard requires the Secretary of State to issue a code of practice on handling monitoring data, ensuring consistency and clarity for law enforcement. This clause on electronic monitoring for those subject to serious crime prevention orders will enhance the effectiveness of such orders and interim crime, serious crime prevention orders, supporting efforts to disrupt serious and organised crime, reduce harm and protect the public. With that in mind, Dame Siobhan, I move the clause stands part of the bill.
Katie Lamb.
Thank you, Chair. Clause 46 allows the courts to impose an electronic monitoring requirement as part of the Serious Crime Prevention Order. This clause is helpful for investigating suspects already in the UK, and broadly we support it. Can the Minister please confirm that the requirement for electronic monitoring will apply to those on immigration bail? And what value does the Minister feel that serious crime prevention orders might have for deterring those operating abroad? Clause 46 specifies that there will be a code of practice to outline the expectations, safeguards and broad responsibilities for the data gathered, retention and sharing of information on these orders. When will this code of practice be issued, and can the Minister outline please what the Government expects to be included?
Will Forster.
Thank you, Chairman. Pleasure to serve under your chairmanship. I'd like the Minister to define electronic monitoring for us, if she can. I don't believe this bill has a definition, and I don't believe other acts passed by this building have such a definition. And I worry because of that, that confusion. So I'd welcome her thoughts on that. Thank you.
Thank you, Dame Siobhan. We are talking about electronic monitoring in the context of serious crime prevention orders here. We are not talking about it in connection simply to being an asylum seeker or a migrant. So I wouldn't want members opposite to mix up those two things. This particular section of the bill is about what we can do to deal with serious and organised criminality, some of which will be about people smuggling, some of which will be about perhaps drugs or firearms, other serious organised crime. I wouldn't want members of the committee opposite particularly to worry or mix up those two things. This is electronic tagging within the context of serious and organised crime orders or interim serious and organised crime orders being granted, and that has to do with seeking to disrupt and prevent the activities of serious organised crime groups, not just general asylum seeking or migrants. Obviously there may be some connection between the two, but it's not direct in this area. These orders and their conditions, such as electronic monitoring, therefore won't apply to migrants generally. Serious crime prevention orders are used by law enforcement agencies to manage those individuals who've either been convicted or suspected of serious criminality, where the order will protect the public, preventing, restricting or disrupting the person's involvement in serious crime. So serious crime prevention orders can be imposed on offenders for a range of offences relating to people smuggling. The specific conditions of the order will be a matter for the judge in the High Court who makes the order, and the law enforcement body making the application. So it's a very focused issue, and it's all about the particular context of the individual that has been served with such an order. To do that, there has to be evidence of their involvement in serious and organised crime. Clearly, tagging is about being able to check where people are. Electronic monitoring can be of other activity too. And it's an issue that will apply in a particular context to a particular person for disruption reasons. So there isn't one definition of electronic tagging. I hope that that sort of helps the Honourable Gentleman understand what it is and what the monitoring is that we are talking about. And on that basis, I hope that members of the committee will agree to the clause before us, clause 46.
The question is that clause 46 stand part of the bill. As many are of that opinion, say aye. Aye. To the contrary, no. I think the ayes have it, the ayes have it. We now come to the question that clause 47 stand part of the bill, with which it will be convenient to debate Schedule 2. Minister.
Thank you very much, Dame Siobhan. Clause 47 introduces interim serious crime prevention orders as part of the wider regime of serious crime prevention orders established under the Serious Crime Act in 2007. Interim serious crime prevention orders are designed to protect the public while a full serious crime prevention order application is considered. The court can impose an interim serious crime prevention order within hours, imposing a range of conditions and restrictions to disrupt further criminal behaviour. For example, anyone suspected of being involved in people trafficking or other serious crime could face bans on travel, bans on using the internet and mobile phone use. Interim serious crime prevention orders will allow enforcement agencies to act swiftly to prevent, disrupt or restrict serious offences before they occur. These are the counter-terrorism style powers which attach to this bill. It's about disruption, it's about prevention. It's not necessarily about waiting until the harm has happened and then arresting people for causing it, but trying to prevent danger and the harm happening in the first place. Interim crime prevention orders will allow enforcement agencies to act swiftly to prevent, disrupt or restrict serious offences before they occur, stopping offenders from reorganising or destroying evidence. This clause allows without notice applications, enabling interim orders to be made without the individual present if notice could undermine the order's effectiveness. Additionally, given that this is a powerful tool, Clause 47 provides key safeguards, including the requirement to serve notice of an interim serious crime prevention order within 7 days, and to allow individuals to challenge the order in court via the appeal process or on application to vary its terms or discharge it. This is not without precedent, and interim orders are successfully used in areas such as sexual risk and modern slavery, where the urgency to protect the public justifies temporary restrictions or requirements on individuals. Clause 47 will enable the National Crime Agency, police and other law enforcement agencies to act more quickly than current powers allow to protect the public from serious criminals, including those engaged in organised immigration crime. Schedule 2 of the bill introduces a series of consequential amendments to the Serious Crime Act 2007 to extend existing provisions to interim serious crime prevention orders. These amendments ensure that interim serious crime prevention orders are governed by the same legal safeguards and processes as full orders. Key provisions include extending protection for individuals under the age of 18, granting the right to make representations in court, and aligning rules for the duration, variation and discharge of orders. The amendments also apply to bodies corporate, partnerships and unincorporated associations, ensuring accountability if they breach an interim serious crime prevention order. Schedule 2 ensures that interim serious crime prevention orders have the same effective safeguards as serious crime prevention orders, while strengthening the legal framework for preventing serious crime.
Katie Lamb.
Thank you, Chair. Clause 47 introduces a new provision for interim serious crime prevention orders. These allow the High Court to impose immediate restrictions pending the determination of a full serious crime prevention order application. The Court can do this if it considers that it is just to do so. Can the Minister explain a little more by what process the Court will decide whether it is just? Is the criterion that it is necessary for public protection? 5F makes provision for without notice applications. This is where the application for an interim serious crime prevention order or variation of an interim serious crime prevention order is made without notice being given to the person against whom the order is made in circumstances where notice of that application is likely to prejudice the outcome. Subsection 2 makes provision for the Court to allow the relevant person to make representations about the order as soon as reasonably practicable. Can the Minister explain whether this will always happen after the order is granted?
Thank you very much, Dame Siobhan. The High Court will be empowered to impose an interim serious crime prevention order if the Court considers it just to do so. It's not an evidential test, in other words, because the Court does not apply a standard of proof. Rather, it invites the Court to impose an order before it has heard and tested all the evidence in instances that require fast-paced action to prevent and disrupt serious and organised crime. It's therefore an exercise of judgment or evaluation, and there's a precedence for this approach in relation to interim sexual risk orders and interim slavery and trafficking risk orders, which are currently a feature of the system and work reasonably well.
The question is that Clause 47 stand part of the bill. As many are of that opinion, say aye.
Aye.
On the contrary, no. I think the ayes have it. The ayes have it. Schedule 2 has just been debated with Clause 47. We will therefore proceed straight to the question. That Schedule 2 be the second schedule of the bill. As many are of that opinion, say aye.
Aye.
To the contrary, no. I think the ayes have it. The ayes have it. We now come to the question that Clause 48 stand part of the bill. Minister.
Thank you, Dame Siobhan. Currently, the High Court can make a serious crime prevention order only upon application from the Crown Prosecution Service, the Serious Fraud Office and police in terrorism-related cases. However, High Court serious crime prevention orders have not been fully utilised. Between 2011 and 2021, only 2 applications were made, and only 1 resulted in a successful order. Clause 48 extends the list of agencies who can apply directly to the High Court for a serious crime prevention order or an interim serious crime prevention order to the National Crime Agency, HMRC and the police in all cases, including the British Transport Police and the Ministry of Defence Police. The clause also specifies who within each agency is authorised to apply for these orders. This extension will simplify and expedite the application processes for serious crime prevention orders, making it easier for those agencies directly involved in tackling serious crime to make an application where appropriate. It gets rid of a gateway process which has proved to be so tight that it's not allowed very many of these orders to go forwards at all. So these agencies are often best placed to apply for a serious crime prevention order as they will already have an in-depth knowledge of the case. The clause also requires the CPS to be consulted by the applicant authority, as they will continue to have responsibility for ensuring the order is not used as a substitute for prosecution, which is a very important part of ensuring that these work appropriately. In practice, this clause will make serious crime prevention orders more readily available to the agencies that are most likely to use them, to ensure that this powerful tool is used to best effect to protect the public and prevent, disrupt serious and organised crime.
Katie Lamb.
Thank you, Chair. Clause 48 details who can apply to make orders and interim orders and replaces and extends the list that was previously in Section 8 of the Serious Crime Act 2007. Can the Minister explain, please, how long an application for an interim serious crime prevention order may take when made to either the High Court or the Crown Court?
Anyone else wish to interpret? Tom Hayes.
Thank you, Chair. I really just wanted to reflect on where we're up to in terms of movement through the clauses at quite a pace, which is very pleasing to see. I think what we're seeing here is a bill which is responding to the request by operationally and frontline focused people, law enforcement, our border security, and trying to give them the tools and the powers that they need. And I particularly wanted to kind of reference that in the context of the interim serious crime prevention orders that we were just talking about in the previous clause, but also here with this particular set of measures too. And I think that cuts such a sharp contrast with what's happened over recent years. In 2022, we had one Home Secretary introduce the Nationality and Borders Act. At the time, the government said it would deter people wanting to cross in small boats. It didn't. In 2023, we had another Home Secretary bring in the Illegal Migration Act. At the time, the government said that it would turn away people from crossing the channel in small boats. It did not. And then in 2024, we had another Home Secretary bring in the Rwanda Safety Act, which happily we've just repealed today. And at the time, the government said that they were talking about the prospect of sending people to Rwanda, and that alone would be sufficient to deter people from crossing the channel in small boats. So it's no wonder that that failed too. So I really just want to set out how in 2022, 2023 and 2024, we've had 3 separate acts. They've all aimed to do something, they've all failed, and they haven't actually delivered
what operationally focused people have been requesting. And I think we really do need to look, just 8 months into this new government, with the turning of the page in our asylum system, we're giving our enforcement powers to the people who need them, and we're also making sure that we're tidying up the statute book, and we're making sure that we've got greater coordination across the key agencies that are able to take forward the securitisation of our border. So I really do commend this clause, the series of clauses before it, and the bill overall.
Minister? Thank you very much. The idea of creating interim serious crime prevention orders is to ensure that they're brought into use ahead of the more long-lasting serious crime prevention order, and the widening of those organisations that can apply for them is really to put empower organisations such as the National Crime Agency, HMRC, MOD, police to apply because they're much closer to the evidence of disrupting a particular serious organised crime group. The Honourable Lady asked how long it would take to get such an order. It depends on, it's a case-by-case basis. It depends on what the evidence is. I've already pointed out to her in the previous clause that this is about the High Court reviewing the papers. It's not about a trial or a pre-trial. Just to issue an order that will prevent something that might happen and cause damage from happening. So we think that making these changes in the clauses that we've just been talking about all the way to and up to and including clause 49, which we're discussing at the moment, will make it more likely that serious and organised crime orders will be used and will be effective.
The question is that clause 48 stand part of the bill. As many are of that opinion, say aye.
Aye.
On the contrary, no. I think the ayes have it. The ayes have it. We now come to that clause 49 stand part of the bill. Minister.
Thank you very much, Dame Siobhan. Clause 49 amends the Serious Crime Act 2007 to introduce a standardised list of notification requirements for individuals and bodies corporate subject to serious crime prevention orders. It's a standardisation process. Currently, notification requirements are added at the court's discretion on a case-by-case basis. This clause will standardise these requirements for all serious crime prevention orders, improving consistency and monitoring of the orders across police forces. We have worked closely with law enforcement partners to identify appropriate requirements. This standard list will include monitoring legitimate income, checking addresses or communication methods for signs of establishing their criminal activities, and monitoring foreign travel to assess the potential indication of a return to crime. The courts can then impose additional requirements and conditions as part of the serious crime prevention order where necessary. For bodies corporate, a designated individual must be named to liaise with the police and provide the notifiable information, including personal details, employment, financial data and contact information, which is essential for law enforcement to ensure compliance and assess risk to public safety. The clause includes a delegated power to add to the list of notification requirements, ensuring flexibility to meet operational needs as technology evolves. The statutory instrument will be subject to the draft affirmative procedure. Individuals subject to a serious crime prevention order must provide the notifiable information within 3 days of the order coming into force. Failure to provide or providing false information will be a criminal offence, punishable by a fine or up to 5 years imprisonment. Standardising notifications will improve consistency in managing serious criminals and improve the ability of law enforcement agencies to assess risk and therefore more effectively protect the public.
Katie Lamb.
Thank you, Chair. Clause 49 sets out a prescribed set of notification requirements so that a person who is subject to a serious crime prevention order is required to provide the police or the applicant authorities with certain information. We support this clause, although we'd just like to ask whether the Minister can explain why 3 days has been given as the deadline to respond with the notifiable information requested.
Would anybody else like to enter the debate? I call the Minister.
Thank you, Dame Siobhan, because 3 days seems a reasonable amount of time to allow the individual or body corporate concerned to gather the information, but to have it with the authorities in a timely way to prevent any potential harm that might come from delay.
The question is that clause 49 stand part of the bill. As many are of that opinion, say aye.
Aye.
To the contrary, no. I think the ayes have it. The ayes have it. We now come to the question that clause 50 stand part of the bill. I call the Minister.
Thank you very much, Dame Siobhan. Currently, the High Court has the authority to impose a serious crime prevention order without a conviction, provided that the court is satisfied that the person has been involved in serious crime and that there are reasonable grounds to believe that the order will protect the public by preventing, restricting or disrupting their involvement in serious crime. Clause 50 amends the Serious Crime Act 2007 to grant the Crown Court the power to impose a serious crime prevention order on individuals who've been acquitted of an offence or in circumstances where the appeal has been allowed, if the same two-limb test is met. There may be cases where a person is acquitted, but a serious crime prevention order is still needed. This can happen if the threshold for a criminal conviction is not met, but there is still enough evidence to show the person was involved in serious crime and that the order would protect the public. The Crown Court would have just heard the evidence of the case and would be in the best position to assess whether an order is necessary to protect the public. This approach, again, is not new. Similar provisions are found in other laws, such as domestic abuse protection orders under the Domestic Abuse Act 2021 and restraining orders under the Protection from Harassment Act 1997, where orders can still be issued even after an individual has been acquitted. The effect of this clause is to streamline the process, enabling serious crime prevention orders to be applied more regularly and effectively in appropriate cases.
Katie Lamb.
Thank you, Dame Siobhan. Clause 50, as we've heard, allows the Crown Court the power to impose a serious crime prevention order on acquittal or when allowing an appeal. Subsection 2 provides that in order to impose a serious crime prevention order in these circumstances, the court has to be satisfied both that the person has been involved in serious crime and that the court has reasonable grounds to believe that the order would protect the public by preventing, restricting or disrupting involvement by that person in serious crime in England and Wales. Can I ask the Minister, please, why both tests need to be satisfied for a serious crime prevention order to be imposed? Where these cases involve acquittal, as the Minister outlined, then it might be hard to satisfy the first test, and it seems to us that the second test of protecting the public is sufficient grounds to impose a serious crime prevention order.
Are there any other members who wish to enter the debate? I call the Minister.
Thank you very much, Dame Siobhan. It's a two-limb test. Obviously, the evidential test for criminal proceedings is beyond reasonable doubt. There's a lower evidential test in other court instances, and it may very well be that someone who didn't pass the beyond reasonable doubt test in a criminal trial would still be considered by the court to be involved in criminal activity and therefore would pass the first limb of the test. The second limb is that they would still be likely to be so involved in the future. So we think that the two-limb test is an appropriate response to protect people's civil liberties whilst protecting the public from the behaviour of people involved in serious and organised crime, and we think that that balance is about right.
The question is that clause 50 stand part of the bill. As many are of that opinion, say aye.
Aye.
On the contrary, no. I think the ayes have it. The ayes have it.
I beg to move that further consideration of the bill be now adjourned.
The question is that further consideration of the bill be now adjourned. As many are of that opinion, say aye. Aye. On the contrary, no. I think the ayes have it, the ayes have it. Order, order. Can I thank...
Committee Room 9, Sound.